Now I am going to dictate a legal passage at the rate of 140 words per minute based on latest Supreme Court judgment. Let's start. This appeal challenges the order dated June 2016 within the hearing after referred to as impugned order in special civil application number 4577 of 2016 passed by High Court of Gujarat, wherein the appellant hearing being Rajkot Municipal Corporation within the hearing after referred to as appellant corporation was directed to refund a portion of the property tax which was paid by the respondent number 02 herein, namely Avenue Supermarts Limited Para. Respondent number 02 had assailed the demand raised by appellant corporation seeking payment of property tax for the assessment year within the hearing after referred to as AY 2015 to 16, along with outstanding arrears of such tax dues amounting to INR 2.97 crore as a consequence to the non-fulfillment of aforesaid payment of dues by the predecessor in interest holder of the property. The premises were sealed on 21/03/2016 with prior indication to the respondent number 02 Para. The High Court of Gujarat by the impugned order had allowed the special civil application moved by the respondent number 02 on the ground that the said respondent cannot be made liable for the payment of arrears of property tax which arose prior to the acquisition of ownership, that is prior to 03/09/2015. The High Court deprecated the approach of the appellant corporation in charging exorbitant amount of dues from respondent number 02 as well as the uncalled inclusion of further interest and penalty on such outstanding arrears which had already been challenged by the predecessor and had been stayed by the competent court. Para. Considering the said circumstances, the High Court directed the appellant corporation to retain a portion of the property tax to the tune of INR 14,85,000 relating to the relevant AY 2015 to 16 for which respondent number 02 had acquired ownership and possession, that is from 02/09/2015, and to refund the rest of the amount of property tax along with simple interest at 6% per annum from the date of recovery till the actual payment of refund. In compliance with the aforesaid direction qua refund by the High Court, the appellant corporation has already refunded such quantum of excessive property tax to the respondent number 02 aggrieved by the direction to make the refund of accrued amount of property tax dues. The appellant corporation is assailing the impugned order before this court. Para. It is the case of the appellant corporation that the impugned order directing the refund of property tax is contrary to the provisions of section 139 and 140 of the Gujarat Provincial Municipal Corporation Act 1949 within the hearing after referred to as GPMC Act 1949. It is argued that a commissioner by virtue of subsection within the 1 of section 140 of the GPMC Act 1949 is empowered to recover such outstanding property tax dues from an occupier where a person primarily liable to pay the tax after being duly served with demand notice has failed to make the payment thereof. Para. Moreover, as per subsection within bracket 4 of section 140 of the GPMC Act 1949, such occupier may credit the said payment from a person who was primarily liable to discharge the liability of such dues. Thus, it was argued that from a cumulative reading of section 139 and 140 of the GPMC Act 1949, the appellant corporation was justified in recovering arrears from respondent number 02. Para. Per contra, it is contended by respondent number 02 that the property in question, which is a commercial complex known as Sibling 4 bearing city survey number 5095/1B 5095/1C within bracket P plot number 68 situated at Gondal Road, Rajkot, was acquired via deed of conveyance dated 03/09/2015 from its predecessor in interest, that is respondent numbers 4 and 5. Respondent number 2 would be liable for the payment of property tax from the date of acquisition of ownership and not for any period before this date as affirmed by the High Court. Para. Respondent number 02 points out that respondent number 03, the lessee of the property prior to 03/09/2015, has challenged similar tax demands for earlier years in both the civil court and the High Court, resulting in a stay on recovery actions Consequently, it was argued that until the conclusion of adjudication of such pending appeals pertaining to the areas of any period before 03/05/2015, the appellant corporation cannot make recovery of the said amount from respondent number 02. Stop. Thank you.